What is the IR1 or CR1 visa? That's what we're talking about on today's episode of Sumner School Family Immigration Basics. My name is Emily Sumner with Sumner Immigration Law. Let's talk about this. So the IR1 or CR1 visa refers to a marriage-based green card slash visa. It refers to a process of applying for a marriage-based green card when the foreign national is outside of the United States, or if they're in the United States but plan to complete the application for the green card from outside of the United States by applying for an immigrant visa at a US consulate overseas. The contrast to this, the other option, is if the foreign national is in the United States and is eligible to file for a green card from within the United States, they may go through something called the I-130 and the I-485, sometimes called a one-step process because you file everything together. But in this situation, we're talking about when the foreign national is overseas, living outside of the United States, and will apply for an immigrant visa at the US consulate overseas. Internally, we call this, and other people call this, the I-130 and consular processing. It's all the same thing. So what are the requirements? What are the processes and the timelines? So the requirement for the IR1 or the CR1 is you have to be married to a US citizen. It has to be a bona fide relationship. It can't just be for immigration purposes or for benefits of a green card. And you'll have to show at various steps throughout the process that it is a true relationship. You have to be legally married. It can be celebrated. That marriage can be celebrated anywhere around the world as long as it's legally recognized in general. As long as it's legally recognized where it's celebrated, it will also be recognized in the United States. That means you don't have to get married again once you come to the United States. So you have to be legally married. It does not have to be a big ceremony. If you want to have a big ceremony with family and friends or have a religious ceremony, you can. But for purposes of filing, the requirement is the minimum requirement is that it is a legally recognized marriage. So once you are sure that you're legally married, you can file the I-130 petition. So the US citizen petitioner is the person who will file the I-130 petition. They will sign that petition, submit it to USCIS with documentation of your relationship and other required documentation. The processing time for that really varies. I'm almost hesitant to say because it varies so much. I'm recording this video in February of 2025. In reality, we are seeing right now that this type of petition is taking over a year to be processed by USCIS. That does not mean that will be the case for you. We definitely see outliers, and this changes all the time. So it could take less time or more time than that, but that's what we're seeing right now. Then, once the I-130 petition is approved, it will be sent to what's called the National Visa Center, also referred to as the NVC. The NVC is responsible for gathering documentation for the consular processing, for the foreign national to apply for the immigrant visa at the US consulate overseas. So first thing they'll do is send you an email to ask for the fees, the required fees to be paid to the Department of State. Once you pay those, they're called fee bills. Once you pay the fee bills, you can complete the DS-260, which is the required form, and upload the required documentation to the NVC portal. So the NVC portal, you'll have to upload to that civil documentation that includes things like the foreign national's birth certificate, your marriage certificate, any divorce decrees, death decrees, things like that, police certificates. This is not a complete list. It is not legal advice by any means, so you'll have to confirm that, or if we're your immigration lawyer, we will walk you through that step by step and make sure that everything's uploaded and completed. In addition, you have to submit the affidavit of support. The video just before this one in the series is about high level, the affidavit of support, but you have to submit that form and the supporting documentation. The NVC team will review the documentation that you upload. Once they confirm that everything is correct, that all the documentations are satisfactory, they will send an email that says the case is documentarily qualified. That means they reviewed everything and they have decided that it's highly likely that the officers at the US consulate will accept that documentation. One thing to be aware of when you're uploading documentation to the NVC portal is you want to make sure your civil documents are in alignment with the requirements that are posted on the reciprocity table. If you don't know what I'm talking about, don't worry. That's what we're here for, to help you, our clients, walk through that process and Make sure they have access to that and know exactly what we're talking about. But there are certain requirements, country by country, that Department of State has set out, and the NVC will reject your documentation if they do not believe it meets those exact requirements. So know that the reciprocity table is your friend. You should reference it and do your best to make sure your documentation matches those requirements. So once the National Visa Center has determined that your case is documentarily qualified, the case will be sent to the U.S. consulate. And the NVC and the U.S. consulate will work together to schedule an interview. You don't generally get to choose the time of your interview. Usually they send an email and they say, show up on this date and time. So you generally don't get to choose the interview. Usually they will give you lead time of around a month, maybe 3 or 4 weeks lead time. It does vary, but you do have lead time. You have advance notice of the interview. At the time of the interview, every post has specific requirements. So some posts, for example, require that you send in documents ahead of time. Other times they will have you have an appointment for a document check before the actual interview. Other times you bring it to the interview. Every post, and when I say post, I mean every consulate has specific requirements that are posted or in processes that are posted on their website. So make sure that you check that. You will have a medical exam. Again, very specific instructions. You may have to register the appointment to tell the consulate how you want to get your passport back. All of those details we walk you through step by step. But know that you got to check those because they do change over time and they vary by consulate. Once you have the interview date, you will attend your immigrant visa interview. When I say you, I'm talking about the foreign national at this point. So the person applying for the green card will they'll have the interview at the U.S. consulate. Assuming the visa is approved, the officer will keep your passport so that they can put the actual visa into your passport, and you should get it back usually within about a week or two. Sometimes it takes longer, and it'll be returned depending on the method that you select at the beginning of the process. Or when you start the interview process. When you receive the visa back, it is usually valid for up to 6 months. It can be valid for a shorter time than that, but you will use that visa to enter the United States. When you enter the United States, you will enter basically as a green card holder. So you will receive the green card in the mail within about 2 to 6 months, assuming the visa is approved and everything's good, within about 2 to 6 months after you enter the United States. When you enter the United States, you should receive a stamp in your passport that indicates that you are a resident of the United States, and that allows you to work and it allows you to travel internationally until the time that you receive your green card. Make sure you talk with an immigration attorney if you have questions about that. Finally, the difference between CR1 and IR1 is this. If you enter the United States when you have been married less than 2 years, you will receive what's called conditional residence. That means that the green card is valid for 2 years and you have to file a separate petition to remove those conditions, that's the term we use, within the 90-day period before the green card expires. If you've been married more than 10 years, you will receive what's called permanent residence. That means the green card is valid for 10 years. You have to renew it once every 10 years. The status itself is valid indefinitely, but you have to renew the green card once every 10 years. So that's the difference between IR1, which is a permanent resident, and CR1, which stands for conditional residence, if you've been married for less than 2 years when you enter the United States. I hope that you found this information helpful. If so, I hope you will share this video with a family member or friend and make sure you're subscribed to our channel. We are here to help you navigate this process. If you need help, if you are going to start the process, but you're not sure where to start, how to begin, how to navigate it all, we are here to help you walk through this process step by step by your side and seeing you successfully to the end. Hopefully successfully, there are no guarantees. So if you are interested, you can set a time for a consultation by visiting our website at sumnerimmigration.com, calling us at 804-396-3412, or sending an email to info@sumnerimmigration.com, and we're happy to help you get set up with an initial consultation. Otherwise, I look forward to seeing you in the next video. And until next time, my name is Emily Sumner with Sumner Immigration Law, assisting clients throughout the United States and around the world with family-based and employment-based immigration matters. Until next time.